God bless the child that has their own. This is an adage that commonly refers to owning your own home. For many of us, to achieve this dream, we have to obtain a mortgage. What happens, however, when you can't maintain that dream? You find yourself defaulting on payments. What do you do? Where do you go? Do you have any rights or protection? Find out on the Legal Brief. God bless the child that has their own. This is an adage that usually refers to when one owns their own home. For most of us, in order to accomplish this goal, we have to approach a financial institution and secure a mortgage. And on this show, The Legal Brief, we're going to explore whether mortgages, are they a blessing or a curse? Joining me to get into this discussion would be Jamal Davis, Principal of Oxford Law Chambers. Also, Mr. Keith Seymour, Partner of Ascom Law Chambers. Welcome, gentlemen.
Thank you.
Thank you.
Good to see you.
Let's get into this. Mortgages. What is it? What is a mortgage, Mr. Davis?
Well, Mrs. Farquharson-Seymour, you would know mortgage is a document that's used to secure a loan so that the creditor who's given a loan can be sure to somehow recoup payment in the event that there is unfortunately default of payment. So it's just really a document used as security to procure a loan.
Right. And the Latin, and I think you were very clever to sidestep it. Mortgage means death grip. Yes? Have you heard that before, Mr. Seymour? Have you heard that?
I've heard that.
Yes, death grip. And so just breaking it down now for our listening audience. So you
Yes.
go and you wish to get a home, you approach the banks.
Yes.
And you then secure the funding, the financing, and in order to do so. And that is secured by this document, a mortgage.
Right.
Yes. What about a conveyance? What document is that, Mr. Seymour?
Well, a conveyance is the legal process of transferring property from one owner to another. That process entails doing what is called a title search. And at the end of the day, the root of title, as we refer to it in law, is determined. And you make sure that the root of title is clear at the end of the day for the person whose last name is on that mortgage.
So you're making sure then, so you go, you see a piece of land, you want it. And so if you approach a financial institution and they start the process, they will engage, take counsel, and a title search is done just to ensure that whomever owns the property, the rightful person is the vendor that you think you're dealing with, to ensure that they have, you say, a good root of title and they're properly vested with the property in order to convey that property to you.
That's correct,
Yeah.
because
Well, you heard Mr. Davis say better. Better.
because at the end of the day, when the bank is financing it,
Yeah.
they are part owner of it. So they have a vested interest in you, who are the client, having good title and them having good title. So the process is very important.
And so I usually find as well, particularly for first-time homeowners, the both processes tend to occur at the same time. That conveyance will perhaps be executed around the same time as the mortgage. You're getting the financing from the bank in order to pay the vendor to secure whether it's the property upon which the home is going to be on, or whether it's land and home at the same time. Who can own property in the Bahamas? Who can own property?
Well, okay, I'll take that one, Keen. I would say that anyone who is over the age of 18 who is not a minor can own land in the Bahamas. I think the restrictions really, so let's put it like this. Anyone is able to own property. I think that the prohibition or the restrictions would be persons who are under 18, persons who are not of sound mind, or well, I think it's just really restricted to those category of persons.
Right, because certainly you wouldn't be able to enter into any proper legal document if you don't have your proper mental faculties.
Minors.
Minor, yes.
But even though I say that minors aren't able to own properties, however, you can hold land on trust for a minor.
Yes.
So that in effect, when they reach a certain age, they're able
You
to.
can then revert.
Exactly.
You can revert to them.
And I was speaking to Keith earlier, and we did also mention, yes, of course, in the Bahamas, non-Bahamians also can own land as well.
Yes, and I think the process is just maybe slightly different for them. Certain forms or qualifications that they need to fulfill.
Exactly. They'll have to get an approval from the Bahamas Investment Authority.
Yes.
To own land.
And so likewise, so basically many people, most people can own land.
Yes.
And so it also follows, do you agree then that they can obtain a mortgage? Is that so?
You want to take this one or you want me to?
I'll take
You take
this
this one?
Yeah, they cannot necessarily get
A little different, eh?
It's a little different because you have to approach a financial institution, and most of them have a criterion for their mortgages. And most of them, the criterion mainly is to do with your ability to pay it back.
So to qualify, we all hear this, do you qualify?
You have
Yes.
to qualify.
Are you approved?
People are cringing right now.
Right.
Yes.
Because, and then sometimes if people go into to a facility and they find out that they cannot qualify for this $500,000 loan, that mortgage that they would like, they end up being steered towards a $250,000 mortgage, which is something more suitable to their income. So you have to qualify for that financial institution. So
And of course, that's for another show when you get into debt service ratios and everything else.
that's a part.
But maybe not, Ramona, because
Okay.
I believe Keith here was a former banker.
Yes.
So I think Keith actually knows it quite well.
Quite well, yes, I do.
Okay.
Yes, debt service ratios. They want. Well, for now, they tell you in the process of like 45% should be free.
Of your
so
salary, of your
yeah.
small salary
Of
you're
your small
getting.
salary.
Oh wow.
So in that instance, you kind of pool together. So by the time you and your wife pull your salaries together, you can qualify easier than doing it by yourself, unless you make $150,000 a year yourself.
These gentlemen are referring to most of us, not themselves. That's clear. That's just a little slight humor there. But so it's good for persons to know then that there's obviously some type of review that takes place. But now getting more now into the law that, let's say you qualify for this mortgage and you obtain it. What do you have any rights under the mortgage? Or first of all, before we get to rights, responsibilities. We like to jump to our rights. Responsibilities. What are the general responsibilities of a mortgagor, let's say to the mortgagee, and vice versa?
Right. Well, let's put it like this, that it depends whether you get the mortgage to purchase vacant land on the one hand, or you get the mortgage to purchase a structure,
A home.
okay. Or building on it, right? Because under the mortgage, it has the mortgage document itself has standard usual terms.
Yes.
And obviously, the main term is that you are obligated to pay back the creditor as agreed, and usually that is a separate document called a commitment letter.
Yes.
That outlines your payment terms. But the mortgage provides that you are expected to pay as you agreed with your creditor, and also it has provision that you have to pay interest on top. Obviously, that's one of the ways that the whole banking business works, where you pay interest. So it provides for the payment of interest. But the other responsibilities usually is that in the event that the property has structural building on it, that you must ensure that that building is properly maintained, that you pay for the insurance on
To
that
keep
building.
the value as to what you
Exactly.
you got mortgaged.
Exactly, because you have to ensure that in the event that the mortgage has to be called upon, I think we'll get to that.
Yeah.
That the bank is able to recoup its money. So we
Yes.
want the building to be maintained to ensure that that value is maintained. One of the, I think, misconceptions, though, and I have a case dealing with this situation now,
Certainly.
and that is whether the bank, the creditor, is responsible for paying the insurance on the mortgage or whether it is the borrower. Well, let me categorically say.
Oh, you ready for this, Mrs. Seymour? Yes.
You agree, right? It is the borrower, without a doubt. Right. So.
Why?
Well, first of all,
Yeah.
it's by way of statute. The Conveyance and Law of Property Act actually says that it is an implied term of the mortgage relationship that the creditor has a discretion whether or not to pay the insurance on the mortgage property. And I believe the justification for that has to be that if the bank is loaning you the monies, the property is actually your property unless you fail to pay. So that if the bank then, or the creditor, I say bank, but there's also other creditors as
Mrs.
well.
Seymour, you need to soon get me in now
Right?
because I feel in this death grip tightness. Go ahead.
Let's think about it, right? It is your property.
Yeah.
Right? So that should mean then if it's your own, the obligation has to be on you.
You to sustain and protect it.
Maintain it, protect it, and the like. In addition to that, if the bank has to come out of monies to pay for the insurance, then you would be, the money that they loaned you would have to be less than what you actually would have benefited from, because they would now be paying your insurance as well.
I dare ask, what are their responsibilities? I know
The bank's responsibility?
Yes, it's quite onerous on the mortgagor, the person receiving the loan, but the bank.
Well,
just briefly before we go to a break.
Well, first of all, if the bank has represented themselves to be a bank financial institution,
Yes.
their responsibility would be that if you qualify, that they make provision to ensure you're able to get your loan. They are facilitating the process for you in order to get whatever
you qualify for your money.
Precisely.
Yeah.
Right? But other than that, I think the bank's responsibility really comes on the tail end in the event that the mortgage is not being lived up to as it should. And then it kicks in their duty as
to act how they ought to perform and act
in good faith towards you.
Yes.
That is where the bank's responsibility
and
comes
that's a good spot for us to take a break.
Sure.
So when we come back, we're going to be talking about the Homeowners Protection Act.
Sure.
Yes. You're watching The Legal Brief.
Cancer Treatment Centers of America is now City of Hope, creating one of the leading cancer care and research networks from coast to coast, providing more of what you need. More locations means more care closer to home. More specialists means more expertise. More research means more breakthroughs. More advancements means more treatment options. And more options means more hope. Call now to get more of the care you need.
I'm so excited and I just can't hide it. I hope you're ready for the newest sports show that's coming to your television set. It's called Time Out. We'll be bringing you off-the-wall conversations, not only here in the 242, but throughout the entire world. Wherever they are, we are going to find them.
Welcome back. We're discussing mortgages. Are they a blessing or a curse? And just before the break, I could see that Mr. Seymour, you wanted to jump in there and definitely tackle or speak to the issue about insurance and the mortgagee, because Mr. Davis, don't let Mr. Davis go on the show, please. He has it down pack with respect to the rights of the financial institution. But what is it that you wish to add?
Well, according to the Homeowners Protection Act, the mortgagee is the financial institution and the mortgagor is the individual. You indicated the responsibility of the mortgagee. Now, with respect to insurance, insurance is very important because the mortgagee protect themselves by having in the commitment letter that you have to pay the insurance. So that is covered there. Even though, as Jamal put it, it's in the law, it's in your commitment letter that you signed, so you need to pay. And one of the big responsibilities for the mortgagee as well is they have to keep track of your payments. When you may, as you make your payments, they have that what they call an amortization schedule. Now, the amortization schedule, banks don't like to talk about it, but because of the rate of interest, and you're going through an amortization schedule, the majority of interest is paid more than principal. And as the years go by, it swaps.
You start to get more.
So at the beginning, you're paying a bunch of interest
first. You know that, didn't you?
So they keep
learning.
so they keep track of your loan, and they are obligated by law to provide you with statements regarding your loan.
I think you get 2 free statements each year.
Yes,
based
yes.
on this. And so too, we're getting into now the Homeowners Protection Act of 2017.
Yes.
This was long awaited legislation. It came. And so I just want to know from both of you, does it provide protection as encapsulated in the name in particular for the mortgagor? Does it provide that protection?
Well, I certainly will say so. And the reason I say that is sevenfold. Firstly, that there is this case, I think it was decided, it's a case dealing with the Royal Bank of Canada. And in that particular case, the bank brought an action to recover possession of property against an individual. And the case was actually decided against the bank. And the reason it was is because the bank did not comply with Section 4 of the Homeowners Protection Act that provided that the demand letter had to be served in the first instance.
And at least 1 month.
At least 1 month.
Before you commence legal proceedings. I think you and I had a little issue.
Oh, yes. But that was resolved in a proper way, you know? Yes.
But whenever, I think it's always, and for persons to know who are listening in, when we're referring to Section 4, so if you default in a mortgage, and that meaning that you're not paying it as you should, as agreed, because it's not always if you miss payments. I think people have that misconception. It could be that you're not paying what you should.
That's right.
You should not be. You're not paying the correct amount. You're paying less this month, or
that's right.
So therefore, the bank is considering that you're in default, and so before they commence any proceedings, this act says they must serve you. Yes.
That's right.
And that's either by registered post or personally.
Yes, right.
You have to be served because there needs to be proof. And I think my learned friend would know sometimes that tends to be somewhat lacking.
Yes,
and
but
these
once
big affidavits.
twice shy, so you don't worry about that anymore.
When I came at him with that, you know. But it's good to know that there is some legislation in place to protect homeowners. And what is your view, Mrs. Seymour? Does it provide real protection for homeowners?
I think it can go further. I know we'll get into it a little later.
Yes.
But with regards to people who are in default, sometimes people miss a month, miss 2 months, and they think that it's it's monumental and they're gonna lose their loan. But what they ought to do is they ought to approach the bank. The vicissitudes of life put it in a way that some of us, it only takes one event to throw us off of our financial schedule. Right. So if you go back to the bank and you let them know, hey, I've lost my job, I've had a death in the family, we have to pay, for the funeral expenses, this is throwing me back. Please, rewrite my loan or whatever. But if you approach the bank, that's better than the bank's collections department.
And then just, taking the ostrich approach.
Yes.
Burying your head in the sand.
Think it's going to go away.
Sometimes people are just so embarrassed, isn't it? That something that is so very important for many of us, our home, and you're not able to pay or keep that.
Sure.
That you go into fright. I think there's a type of fear, and then you're like, okay, well, if I don't answer them, then persons may even think, if I don't approach them, then perhaps they won't notice.
That's what they think.
No, they notice.
Right.
They do. They have a record.
They have records. And so it's good to know that you get that letter. And so, gentlemen, so once a homeowner receives this letter in accordance with Section 4, pointing out that, okay, you're in default, and I think it's a demand,
Yes.
demanding the full repayment, your advice to them would be what?
Well, just before I answer that, Mr. Seymour, I'll also say though that I believe that from the provisions under the Homeowners Protection Act, it really seems that the intent behind it was to bring the mortgagee on the one hand and the mortgagor on the other hand together to talk.
Yes,
right?
the bank and the borrower
yeah.
together.
So as Keith mentioned earlier, and as you just mentioned as well, no, the whole purpose behind it is not for you to bury, but to give you that leeway to come and talk to your creditor and see what can be worked out, what can be arranged.
Mhm.
In fact, the demand letter that we just referred to is mandated under Section 4 that demand letter has a stipulation that for the borrower to reach a particular individual at the bank to see what arrangement can be worked out. Right? So the whole purpose of this act is to get the parties talking so that taking possession could really, really be the only and last resort.
Last resort,
Yeah.
yes.
One of the things, Ramona, that we need to also look at in terms of the meeting between the mortgagee and the mortgagor.
The bank and the individual.
Bank and the individual.
The lender, the
Yes,
borrower.
simplify it, yeah. That when one gets off of their payment schedule, it is quite normal for bank systems to go off of schedule. And when we
really?
don't find that out until the reconciliation is done in court. You find that the interest and the when they miss payments, it throws their amortization schedule out of whack. So what has to happen is there has to be a manual adjustment. And if they don't, a lot of banks don't know about it or they don't do it, but they are forced to do it at the end of the day. And that is the only way you can regularize it. But if you miss a payment, you can end up with a perpetual loan being delinquent if they don't fix it.
And I've heard that, so much of that.
That's
I think you have as well.
Yeah, definitely.
Yes, so that's interesting to note. And wow, Mr. Seymour, I know, they don't like
I'm
it.
looking at operations on the other side. I'm on both sides.
That's right now, saying, wait a minute now, what are you saying? But we're gonna explore that further when we return after the break. You're watching The Legal Brief.
Cancer Treatment Centers of America is now City of Hope, creating one of the leading cancer care and research networks from coast to coast, providing more of what you need. More locations means more care closer to home. More specialists means more expertise. More research means more breakthroughs. More advancements means more treatment options. And more options means more hope. Call now to get more of the care you need.
And we're back and discussing a very important topic, mortgages. Is it a blessing or a curse? And in particular, before the break, Mrs. Seymour, you were giving us a real nugget there about re-amortization, that the banks can do so manually. And you've seen them do it in the past, but albeit at the stage of litigation.
Yes.
I don't know if there's anything else you wish to add.
Yes, I'd like to add that during the amortization process, as indicated, the majority principal is paid at the beginning. But majority interest is paid at the beginning,
Right.
and it goes down
Until you reach the principal.
Principal side. My point is that when you look at the interest rates in the Bahamas, they are very high. And in terms of the amortization schedule, persons can find themselves paying their mortgage 3 times when they
Wow.
really look at the numbers at the end of the day.
3 times.
So when we look, and I think in the spirit of what Jamal was talking about, when you go to foreclosure, you're looking at someone who would have paid all of that interest for the first 10 of 20 years.
So basically, the bank has really made their money back.
They have made their money back. So it
And they're
should
the
be.
second or third round. I hope you're hearing this. That's Mrs.
I'll chime in with that.
They're on their
So-
second round.
It's not necessarily like that.
Hey,
Please put it down correctly, but
Go ahead. I know what you're saying.
there ought to be some degree of leniency
Yes.
when you're talking about fault.
When you look at what they've already
And
collected.
also within the U.S. as well, when they look at the mortgages, when mortgages reach a certain point, they allow you to recoup some of the equitable payments that you would have made
Yes.
to do home repairs, or you can put it onto your mortgage.
I've heard that,
is
yes.
that is where we want to go with regards to
When you were saying that this act can go further.
Yes, that's
So,
what I'm
so
saying.
before, yeah, go ahead.
Yeah, well, I mean, I am not, yeah. Yeah, no, that just sounds sort of like horrific to hear that.
That's like gouging, doesn't
Three,
it?
three times or more of the money you borrow, you know?
I don't know.
Yeah, I can certainly say there's not any of the financial institutions that I represent.
Of course not.
I've seen that type of practice occurring. So I can't really say that I can share in Mrs. Keith's words there. Right? No, and I'd be very surprised if so. Right?
That's happening.
Yeah.
Okay.
Right. But the point that I want to make with all of that is that we are going to talk about after the demand letter is served, right? I think what I really wanted to say that there's still a real chance of saving your property at that stage. I think that so long.
So it isn't, they're not just going through the motions because of Section 4. You feel as if you're saying, as counsel for many financial institutions, when they serve that letter, that's an invitation to come in. Let's work it out.
Exactly, that's right, precisely. Because what follows that letter, I'm not sure if we do it now or we go it later, but really what follows that letter is litigation.
Yes.
And when litigation takes effect, then I think that the court hands become somewhat circumscribed or tied.
Yes.
Really. So at that stage, you gotten a demand letter, you know, use that as an opportunity really
To get into that bank, and they usually have these credit departments.
right.
And start talking. Now, on that note,
And especially, like you said this to Ms. Seymour, especially the arrears. I think the bank at that stage is really looking at the arrears being covered. So as opposed to having to repay the entire sum outstanding on the mortgage, at that stage, I think the bank is looking to have the arrears satisfied. And if so, that's a home saver.
One of the things
yes, go ahead.
too that and to add on to what Jamal is saying, when you talk to the bank, they have another suggestion that they make, which is a very practical one. They ask you to make 6 or 7 months of payments,
That's right.
consecutive. Consecutive.
Right, consistently.
Now, when you do that consecutively, they are now prepared to rewrite your loan. I mean, that is one way of doing it, but you cannot do it unless you go in and talk to them. Sometimes you lose your job and you get another job, so you can always go back to them and and they will say, hey, make some payments, and these will go directly to principal, and once it is done at the 7th month, we will rewrite your loan from there.
Now, on that point, because it's been my experience, and I want to know if you share this view. Clients would say that invitation has been given to them to pay 6 to 7 months to show consistency. Whatever arrangements they have said to the bank, I've recovered or I've gotten assistance, I can do so. However, the bank would say to them, because of the matter being in default, they have removed it. So therefore, you are not able to pay to the branch itself, but they prefer you to pay to at the collections department. And so really nothing is being applied directly to the loan. You're paying to the collections department, and you'll be paying every month, and you're saying, well, why isn't my loan, why am I not seeing movement in my loan? And they're saying to you, no, that's fine, ma'am. You just continue paying, and after the 6 to 7 month period, we see the consistency, then we'll rewrite. However, I've had clients who say, I've done that, I have proof of it. They've told me to do this, I've done it. However, they still take me to court and say no, they want to repossess. Have you ever had that experience or heard that?
Well, and the answer is no to both cases, right? Because it'd be quite alarming to hear that the borrower is paying monies, but that money is not being reflected on their loan account.
It's just sitting at some account at the collections agency. Yes.
Well, no, I haven't had that experience, and I would say that the only reason the account is transferred to a collection agency is because there's more specialized attention to the account because of the status that it is under now. But it doesn't mean that the account changes as far as
So those monies should still they should still be applied. Then to the
definitely. I really
mortgage.
see no reason why they wouldn't still be applied. And I haven't had that experience.
Right.
I haven't been applied.
Mrs. Seymour?
I have not seen that happen, Ramona.
Okay.
I think, as a matter of fact, the instances that I know of that I have worked when I was in banking, they always would apply, and they would apply some to principal and some to interest,
Okay.
just to show, as you indicated, that there's a degree of consistency, and then it will be rewritten. But to take them to court after that,
Yeah.
that is really not fair. If that has happened, that is what the Homeowners Protection Act.
Nah, would guard against. Now, unfortunately for me, in going through this act, for me, it lacks teeth, more teeth. I mean, yes, Section 4, if you don't do it, if the bank doesn't do it, then they can't go ahead and take you to court. But let's say, yes, they do serve you the letter. The spirit is for there to be conversation,
Yeah.
but there's nothing mandating that. To say, for instance, there seems to be now what we would call good practices that the banks have established because of the act, to say, well, I'm going to give you an opportunity, whether half a year or so, to show consistency. But there's really nothing in this act, is there, that mandates or that says that they have to do that?
Well, the mortgagor, Ramona, has a right to, through this act, to request relief from the court.
Okay.
And once they go into to the courts, and the court make that determination that it's not fair, the court can either dismiss the foreclosure or delay the foreclosure based on this act. So it does have some
So you
it ain't got enough teeth to
Not for us,
reinstate, but it seems that the mortgagee still has the upper hand. But you can, as a mortgagor, delay things and have things.
Well, I'd like to say this, Keith is entirely right. That because if you look to the law prior to the coming into force of this act,
2017 act.
right, and the law really, I think, was established by the case of Citibank versus Major, a Court of Appeal decision.
Yes.
And really, the Court of Appeal decided in that case, and it is now in wide circulation, that really the court hands are pretty much tied when you default on your mortgage. The most that the court really could have done prior to the implementation of this act is to give you a 1-month adjournment to try to find ways to pay off the debt. Right? But as Keith said, the act now allows certain
That
protections.
they can dismiss the application.
That's right.
Delay it.
So there's far more, this gives far more protections than had existed prior to the.
And Ramona too, it also goes far in terms of interest as well, because interest, and not only interest on real property tax as well, where it can be either cut in half or eliminated.
Okay. So thank you, gentlemen. That's been very enlightening. When we come back after the break, I want us now to discuss litigation. Once you've received the letter, you've made arrangements, unfortunately it hasn't worked out. You've now received this originating application. What do you do? What are your rights? What happens? You're watching The Legal Brief.
Cancer Treatment Centers of America is now City of Hope, creating one of the leading cancer care and research networks from coast to coast, providing more of what you need. More locations means more care closer to home. More specialists means more expertise. More research means more breakthroughs. More advancements means more treatment options. And more options means more hope. Call now to get more of the care you need.
Kim, an all-around busy person, but I'm also a foodie. Bahamian food is a delightful fusion of flavors and techniques passed down and over time has evolved into unique and delicious meals. It takes simple ingredients and it turns into something special. So if you're a foodie like me and don't like spending all day in the kitchen, but want great food, fast, simple, and tasty, then join me as we dish it up.
We're discussing mortgages, and specifically in our last segment, we're looking at the rights, whether this Homeowners Protection Act really provides protection. And I'm happy to see that both of you agree that it does, that certainly it's much better than what we had, which was almost like nothing at all. But now here it is, the courts have the power, they can dismiss applications brought by the bank, as well as they can delay or suspend. And so giving time, obviously, for the homeowner, I think there's a thought that no one wants someone to lose their home.
Yeah.
That's certainly the last resort. But let's now look at the difficult decision or whatever it may be once you have received that originating application from the bank saying that we want, it's always this, hey, vacant possession. Yes, Mr. I think you have that just in your computers, just ready to be printed off. Vacant possession.
Can I send you a piece of
No. You have it. Vacant possession. He's teasing because I usually represent the individual, but vacant possession or pay the debt in full. What should you do? Mr. Seymour, we'll start off with you when you receive that document.
Well, I always let my clients know as soon as they, or anyone I know, as soon as they receive a document like that, they seek counsel. And certainly, once you seek counsel will review the document and take instructions from you with respect to answering, with a defense. And then once the pleading's closed, then
Because again, it's important because there are time frames involved.
there are time frames.
Again, you cannot or you shouldn't take the ostrich approach. You agree, Mr. Davis?
Yes, definitely.
Yes.
That's right.
So when you get the document, what's the usual time frame for you to put in an appearance or even put in your affidavit or defense?
Well, as you know now, Ramona, you don't mind me calling you Ramona,
No, sorry,
right?
go ahead.
Okay, as you know, Ramona, we've recently reformed our civil procedure practice.
Since the 1st of March this year.
Exactly, that's right. So now the process, the time period seem to be the same, which is that you have the acknowledgement of service that has been within 14 days. And that document, it actually says what position you're going to take.
Yes.
So I think it's
Whether you're gonna
it's more layman's friendly now because if you read it, and I think one of the challenges that we have, and that speaks for a number of us, we get documents and we don't read it, right? But if we actually
panic mode.
right, if you take the time to read it, it really sets out what course of action you should take in the event that either you accept that you are indebted to the mortgagee, or if you're not indebted to the mortgagee. It tells you what you should do,
Yes.
right? But as Keith said, right, you really receiving any documents, perhaps you want to consult an attorney for legal advice.
I always say that because, again, if I need surgery, I'm not going to walk in the hospital without a doctor.
Right.
I mean, or a consulting one, or certainly I would want them there in the surgery. Likewise,
Yeah.
even though the law says that you can appear pro se at all
Yeah.
times, I would certainly urge against that.
So you get, as Keith said, it is best to consult an attorney, right? As you get any legal documents, right? But and those documents now, because they're being reformed, they really set out directions for the person who's being sued to see what course of action they
The
should take.
homeowner, so that they know. Yeah.
Right, whether they want to defend the proceedings or whether they want to accept responsibility. Now, what I really wanted to say, and as I said, it probably is a bit biased, but from practice, I would just say that in the event that you know you are indebted to the bank, right? Don't look. I wouldn't. I would advise really against looking for cover and looking for things or potential issues that really can be resolved very easily by a discussion with the bank, because looking for
You say it's surrender.
right,
Throw your
right,
hands up and
I'm
surrender.
not saying surrender, not at all.
Uh-huh.
Because remember now, I'm also a homeowner and I'm also a mortgagor. So I wouldn't say surrender. What I'm saying is that look, in the event that you know that you are indebted to the bank, you are in default,
Yes.
right? To really be seeking to delay and provide this defense that's not sustainable in law and the like is only going to cost time, cost you money, and potentially you may not get the best result.
What if
you
that
possibly
client is
can
saying
get.
that's the time I need? What are they thinking that's the time
A
they
simple
need?
conversation, Ramona, a simple conversation
Okay.
with the creditor can really help to
Now,
provide that.
now you say that because I found as well that whereas as counsel, you say you're a homeowner, you may sympathize, you still are a creature of instruction.
Yes.
And if that bank says to you, no, we're done with that client, we've given them enough time, then really your hands are tied as well. Isn't that the case? That you can't give additional time if a case is made out to you as counsel, and it's well reasoned, and you know.
Well,
just
thank goodness from the creditors that I've worked with that if we get to that point, let me tell you, that is really the final point, because I do know that they go a long way to avoid actually pursuing matters. And as soon as there's some hope of a redeeming the mortgage or satisfying the arrears, I get that email right away. Put these proceedings on hold.
Really?
Yeah.
Now,
I'm telling you.
now I know. I hope persons sitting there and saying, "Ms. Farquharson, this has not been my reality." I guess we hear so many horror stories. For instance, I hear often where people, they would come in and they say, "Ms. Farquharson, the bank has served me a letter, and I can tell you, I know that someone in the bank wants my home. They want my home, or their family member wants my home." Don't you always hear it?
But I think he wants to say something like that, right?
Hey,
I'll
you've
give it
been
to
in the mic
He wants to say something like that.
with me with this. You've heard this.
Yeah, but Section 12 of the Homeowners Protection Act
Yes.
certainly rules against that. If you are, you know,
Not only the immediate family, but they sometimes they sort of have a little eye, don't
you
they?
cannot practice insider trading. That's what it amounts to. But and it takes away the fairness. One of the things that the Homeowners Protection Act does to me is it brings fairness. It doesn't have to appear fair, but it brings fairness, you know, to the process.
It's interesting that Mr. Seymour says that. But again, I had to put it out there because we hear it so often. People say that the persons in the bank, they were eyeing their homes or their family members, or even some people, I've even had clients say, "Ms. Farquharson, they repossessed my home," and it's somebody who works in the bank who purchased. Maybe not that bank, but another bank. And so, of course, persons, they work together, they're interconnected in financial institutions, and they purchase. And so sometimes it leaves a very bad taste in the mouths of
The borrower.
of the borrower.
So-
When things like that happen.
Certainly the law is not on their side with respect to doing that, actually.
So when we come back after the break, and these segments are just rolling.
Yes, yeah,
The
time's
time,
going.
yes, for us to look at and explore perhaps what means of reforms. We're happy we have something. We're happy we have a Homeowners Protection Act, but as you were saying before, Ms. Zimmer, it could go further. Mr. Mr. Davis may not agree, but I think it could go a lot.
I remind you, Ramona, I am a homeowner. I am a so whatever benefits.
I have a heart. I have a heart. I don't know if I see that so often, but I'm You're watching The Legal Brief. I'm your host, Ramona Farquharson.
Cancer Treatment Centers of America is now City of Hope, creating one of the leading cancer care and research networks from coast to coast, providing more of what you need. More locations means more care closer to home. More specialists means more expertise. More research means more breakthroughs. More advancements means more treatment options. And more options means more hope. Call now to get more of the care you need.
We're back discussing mortgages. And I'm pleasantly surprised because I was thinking we're going to lean more towards it being a curse. But you two gentlemen seem to be making a believer of me that this death grip may be somewhat of a blessing, particularly with us having now the Homeowners Protection Act. Let's look at reforms, possible reforms. We're happy, I think we all agree, we're happy with what we have, but there's always room for improvement.
Yes,
This has been from 2017. The world is changing so very fast, particularly in financial services. Should we amend this act to the extent that after, let's say, 20 years of payment, 25 years, that the bank not be in a position to repossess a person's home if the mortgage, let's say the lifespan would be 30 years, like 5 years off of the lifespan?
Right. Well, unfortunately, Ramona, I can't really give an answer to that. I mean, I'm not a banker, so I can't really speak to the practicalities.
But you would love that
of
as a
doing so.
homeowner. You would love it.
As a homeowner,
Yes, yes.
right? Definitely. But I can say, though, that under the present legislation, the Homeowners Protection Act, it does provide that in the event that the bank has to exercise its power of sale and sell the property, that, and it is really online what you just said, it takes into account the time period that the borrower has actually either been in possession of the property, for one, or secondly, how much monies that the borrower would have paid.
As repaid.
Right.
Mhm.
So the act actually gives protection to the borrower in a sense that in the event that the bank exercises power of sale, sells the property, and when the property is sold, there's still a balance left on the mortgage, be it a 50,000, 100,000, 200,000, whatever amount it is. But if the borrower has actually paid at least 50% of the principal and interest under the mortgage, then the bank is unable to recover any differences on the mortgage loan. So
Right.
that has to be written off.
So once you've paid up to 50% of the principal and all of the interest, because obviously principal comes after interest in the
Well, sometimes actually you pay money. Yeah.
maybe side by side, but the
Right.
majority usually
Goes-
majority of your payment is going to be towards interest
Right,
first, and then
right.
but so if you've covered up to 50% of your principal, then if you get into default and they need to take vacant possession, they can't come after you for the balance.
For the balance, that's right. Or if you've lived in the property, you've had the mortgage for more than 50%, I believe it's section 11.
Yes.
And it says here, subsection 8, save for any surplus amounts referred to in subsection 7, the exercise by the mortgagee of a power of sale shall discharge the mortgage or borrower from any and all liabilities for any sums, if at the date of the sale, a sum equal to at least 1/2 of principal on accrued interest has been paid, or the mortgager has been in occupation of the dwelling house for a period of not less than 50% of the original mortgage.
Right.
So in those events, that's another protection for the
Yes,
borrower.
an added protection.
Yes.
Even though for me, I want us to go a little further.
Yeah, well,
You want your home.
You know,
You want your home.
We did not say this, but Ramona and I went to Queen's College together, and just as she is this fighter now, she was back then. I remember a particular incident in the auditorium, but we're gonna stop right there.
We can stop right there. Mrs. Seymour.
You remember that?
No, I don't know what you're referring to. Mrs. Seymour, do you agree with me that we need to go a little further.
I do agree, and I do agree with my learned friend, Jamal, indicating how far they've gone once it, pursuant to section
11, subsection 8.
in the U.S. and other jurisdictions with respect to mortgages, they have something in there that we ought to consider. In that, if you would have paid your mortgage for a certain amount of time, say half of the mortgage, if it's a 30-year mortgage, 15 years, you would have established a certain degree of equity, say an excess of $25,000, that you can put, that you are able to get back, that you can put back into the renovation of the home, or you can put it onto your mortgage to decrease your mortgage. So something like that would be
Very innovative. I mean, it's,
to the mortgage, or and it encourages good pay. You know,
yes,
once
it does.
people are paying good, then they are benefited and they're rewarded. I think
Yes.
that's a very good thing for
Definitely.
them to consider.
Certainly. It's wonderful. Gentlemen, I have to thank you. This has been most informative. Like I said, you're sort of making a little belief out of me that about mortgages. Are they a blessing or a curse? One thing I believe we can all agree to is that they're necessary.
Yes.
It's necessary.
Yes.
Unfortunately, many of us, my grandmother would say, poorness is no disgrace. It may be a putback, but no disgrace.
Yeah,
And so
that's
we
right.
have to reach out to lending institutions in order to secure financing to achieve that all important commodity, our home.
Yes.
Indeed.
Really defines us to have proper shelter, roof over our heads. And so, again, this has been very enlightening, and it's good to know that there's a protection out there. And for you, the listening audience, now you know your rights. You can now decide, if I approach a financial institution, I secure that mortgage, I know what my rights are. I know what avenues and options I have. I do not have to take an ostrich approach. As our guests would have spoken about, vicissitudes of life, they happen. There are times when you're not able to make your mortgage due to illness, due to death, whatever it may be. Don't stick your head in the sand. Approach your financial institution, make arrangements, be proactive.
That's right.
And if for whatever reason you are served with documents to commence legal action, get an attorney. Move quickly, be present. Because at the end of the day, God bless the child that has their own, and your home ought to be protected. Thank you for watching. This has been The Legal Brief. I'm your host, Ramona Farquharson.